So family dispute resolution, first of all, hashtag FDR is not mandatory mediation. There will be some kind of, I want to say 20 like lashes, but I'm pretty sure that wouldn't be politically correct, but some kind of terrible consequence if I ever hear any of us say there's mandatory mediation. So be very careful. You will hear that. You will even hear judges say that though, because but FDR is not mandatory mediation. It is, however, hashtag lawyer's obligation and duty to talk about. And if you're wondering, it's true that CDP does need to learn how to use hashtags properly, but it's fun to put everything behind a hashtag. All right, thank you, Kelly. It's always nice when the crowd follows along with the jokes, but that's not always easy to do. Okay, we are going to talk about three things today. One, we're going to talk about the legislative requirement for participation in family dispute resolution, the what, when, and the why, so that you understand that this is actually rooted in the law. It's our hedgehog concept because we actually started working in this fashion long before it was a legislative requirement. And so we should be ahead of the curve of everybody else who's still figuring out how they incorporate it into the work they do with families. So we want to refresh our memories as to where this belongs and why it's important to know and why it's a requirement. Which brings us to the second point, is that requirement, our obligations, why we all need to understand FDR. Is it just the world according to Charmaine? No, actually, it's not. Not only is it embedded in legislation for process, it's embedded in the governing legislation for family law matters, and it's embedded in our code of conduct for those of us who are lawyers. And I see Mackenzie nodding her head because if you have any ethical questions ever, she's memorized the code. No, she hasn't memorized it, but she does know it very, very well. So she can be a go-to person. Point number three, and this is probably going to be the most interesting and valuable point, and that is about diverting to FDR, asking the question, what if? And I anticipate that this morning we'll start to get there, but then we're going to build on that next week. Okay. So first of all, King's Bench Act, and if you don't believe me, you are welcome to look it up. I also have it open on my other screen and can post in chat the link to it. Under the King's Bench Act, family dispute resolution lives. That is where the definition of FDR is, and that's in section 7-4. It's defined, and let's look at that definition. It says it's a process used by parties to an application to which this section applies to attempt to resolve one or more of the disputed issues. And then there's finally a comma. And I'll tell you, if I was writing this, there'd be far more commas. Are there comma lovers in the crowd? Okay. And includes the following. Okay, the services of the following persons. So number one, a family mediator. Hence why people will mistakenly say mandatory mediation. It's maybe because it's the first one on the list, but actually I think it's just because it's more commonly understood and known. So put you on the spot. I would like somebody to unmute and tell us what a family mediator does. What is mediation? If somebody asked you, what would you say? Sam.
A family mediator, for the purpose of the act, is a person that has been officially recognized under like the act, and it is part of the registry. And mediation itself is a process that a neutral third party who has training in this area assists the parties to have conversation, designed like a process for that conversation to happen with the hope of helping people to identify their issues and working on a resolution, hopefully.
Thank you, Sam. And key feature here is that family mediator is the neutral, or I like to say impartial, third party. So it's somebody that's not representing either person to the conflict or the application, but they're there to help facilitate the conversation, to help them figure out their pathway forward. So it may be resolving a disputed issue, it might be resolving a whole bunch of disputed issues, or it might simply even be deciding how they're moving forward. Okay, arbitrator. So who wants to take a stab at giving us the definition of arbitration?
Arbitration is the use of a third-party decision maker, where the parties to the dispute present their evidence in a similar fashion that they would in court, and then the arbitrator, using the applicable legislation and case law, then makes a ruling.
Thank you. Now, bonus question. Which is better, an arbitral award that an arbitrator makes or a court decision that comes out as a court order? So you either have an award from the arbitrator or you have an order from the court. Sam.
Well, it is kind of like my personal feeling and opinion about it. I think arbitrator awards are better because it is faster to get like an arbitration. You can reach out to the recognized arbitrators and schedule an appointment versus the scheduling of hearings at the court takes a very long time. And also the process for arbitration is more relaxed in a sense that it doesn't come with the strict nuances that the court has, and also it is less stressful, at least for me when I attended like arbitrations at the city for labor employment matters. You are at a round table basically, versus when you go to the courthouse, the design of the building itself is scary and stressful, where there is a judge sitting at the bench like on top over there, and then there's a gallery behind you that like half of the city's family lawyers are like watching you with their eyes. So these are some of the advantages with arbitration. And also the order of the arbitrator holds a great value, not great value, I mean like it is an order, right? And it can only be challenged if like arbitrator has made correctness or reasonableness issues. So the expertise that goes into an arbitration order is very similar, and I would say unequal to a judge's order. And also the arbitrators kind of have the same experience and requirements to be appointed as a family arbitrator, which is at least 10 years of practice in family law.
Thank you, Sam. So what you have heard Sam describe is that there are advantages to the process. There's lots of various advantages. Sam has named a handful of them. At the end of an arbitration, that arbitral award holds the same weight as a court order. And in some instances, it's a greater weight because it cannot be appealed under the same circumstances as a court order can be. And so I'm going to suggest that arbitration is highly underused, but is currently starting to get some traction. And we always want to remember when we are thinking about the what ifs, when we get to that later, where arbitration might fit in. Okay, parent coordinator, somebody who hasn't had a chance to answer a question yet, who wants to take a stab at telling us what the parent coordinator or parent coordination, what is it? Ebby.
Okay, my understanding of parenting coordinator is an expert that handles specific disputes relating to parenting between the separating parties and helps them take care of those details that might lead to dispute and resolve them as they go through the process of post-separation parenting.
Thank you, Abby. And a key feature here is really about the implementation of whatever has been agreed to or ordered. So in some circumstances, that might truly be post-separation in the sense of everything else has been resolved, but it may also be while they're still working through things because they have at least agreed to or been ordered to a certain baseline. That baseline being, what is the decision-making regime that they are operating under, and what is their baseline parenting schedule? A parent coordinator, their order is a binding order, like a court order, but they are only authorized, they only have jurisdiction to make certain kinds of orders as set out in the legislation. Other collaborative law services, kind of worded strangely, but we are Panko Collaborative Law and Mediation. When we say collaborative law, and that's what's identified here, who wants to take a stab at describing what collaborative law is? And Sam, I'm going to keep you on standby because I want to check to see if somebody else will also be brave and take a stab at the definition.
I don't have the definition in front of me, but my understanding of collaborative law services is that it's two lawyers who have been trained to work with other collaboratively trained lawyers to reach some sort of settlement or agreement for the parties without having to resort to court or like court applications. And typically it's like one party each has like a collaborative lawyer, and then those lawyers will negotiate and try to come up with some sort of agreement. That's my fast and loose definition.
It's an excellent fast and loose definition. I'm going to expand upon it, and I'm going to expand it in two ways. One that says that a collaborative law process does not mean only two lawyers. Sometimes there's only two lawyers, but in that interdisciplinary, holistic, circle the family with what they all need is that we are actively looking to bring into the process who else will be helpful, specifically family professional and financial neutral. Not restricted to those, but those make up the baseline of an interdisciplinary collaborative team. The second feature that is critical to what we'll call the capital C collaborative law process is that everybody who's involved signs a contract. It's a participation contract that says nobody can be involved in an adversarial matter outside of the collaborative process for that particular family. So in other words, any of the other professionals, they cannot be called to lead evidence at a trial. The lawyers cannot continue to act for their client if the negotiations break down and people leave the process. Then that is a critical feature to the capital C collaborative law process. We can always have a collaborative hat on, can't we? Wherein when we think about the different ways of engaging in conflict and the quadrant that talks about a collaborative engagement style, that's where we are picking up the phone and we are talking, where we are calling together to have four-way meetings, or we are exchanging ideas and coming up with proposals. And so that's always a baseline, but that does not qualify as an FDR process under Section 7. What qualifies is the capital C collaborative law process, where the parties and their lawyers, at the very least, if they're not having other supporting professionals, have signed that participation contract. It is taking the adversarial option off the table so that they can focus 100%, and by they, it's not just the parties, but it's the lawyers as well, on working through a plan and creating a pathway forward. And then finally, this nice little catch-all that we see often in our legislation is, anything else we want to throw in. And this is by reference to anything that's prescribed in the regulations. And that was an intentional placeholder to be able to come up with other types of processes that we know exist, but maybe haven't yet been kind of recognized or approved for this purpose. Now, one such thing has been added, which is the Saskatchewan Child Support Services. And we can reference the King's Bench regulations to be able to see where additional processes are identified. Right now, there's just this one. Now, what's critical for us to remember about this as an FDR process is that we will sometimes have clients who child support is a very pressing need. And we do not need to spend money on a court application when they can go for free to the Saskatchewan Child Support Service to get a child support award, which is like an order. And they can check that off by getting them their child support. And technically, it also deals with their FDR requirement. Side note, though, is that it helps resolve one of those issues, but it really doesn't address the spirit and intent behind this legislative section. So when we have clients that we help set them up with the child support calculation service, it's going to be really important that we orient the client to say that you've done this. Now let's look at what are some of the other ways we can engage in other processes to help you resolve the other issues besides just resolving child support. Sam, I know your hand was up and I might have spoke to what you were going to say. I'm not sure, but I'm going to keep going. If there's anything else, please add in chat. So what kinds of applications does this apply to? Anything to do with family law. So the legislation references the sections in the Children's Law Act, other than something that's to deal with family services matters, so child protection matters, the Family Maintenance Act, the Family Property Act, or the Divorce Act. Now, there are some like odd little things that sometimes come up in family law that the rules maybe don't seem to support, that you have to do FDR first. And so there's a little bit confusion there, but that doesn't matter for our purposes. For our purposes, it's thinking about anything that might be necessary for a family to sort out what would be an appropriate FDR process to lead them towards. When do we do this? Well, under the legislation, it says that it must happen before you can move forward. So in other words, when the pleadings have closed, now in family law, the pleadings are your petition and your answer and counter petition. If those have happened, it's kind of like the game of life. Anybody ever played that board game where, you're trucking along and all of a sudden there's a stop sign? So it's kind of like that, right? Is that you could do those initial pleadings and then there's the stop sign. So before you can keep going, you must participate in FDR, and you have to file a piece of paper that shows that you have done that. Now, it doesn't say you must wait until the pleadings are closed. Think about what goes into creating pleadings. The petition and the answer and counter petition. There's time, there's effort, there's cost, and there are positions. And when somebody states their position, that then becomes an anchor that can make it difficult for people to think creatively about what might be possible. Now, it may be important to file a petition, and this is the lawyer's assessment, because there are some legal reasons why you might want to have a petition, but you also have 6 months to serve a petition. So, there could be some reasons to file it, and have it issued, but not necessarily serve it right away because of the impact. And there may be reasons why having your answer and counter petition done as quickly as possible, because maybe the other side's threatening to note you for default, or there may be reasons why setting your position out can actually be helpful. But where we want to be thinking about this, and for anybody who is interested in game theory, I would highly recommend the book, The Application of Game Theory to Family Law Matters, is that in an adversarial environment where you are asking a third party to make a decision for you, if you do not take the most extreme position, Initially, you are at a disadvantage through the lens of game theory, right? When you think about any games, and I'll think of Risk. I don't know if the rest of you have ever played Risk, but I have a family that some members like to play Risk. It's a very long game, but you have to be thinking the strategy, right? You can't just kind of be like handing everything over, hoping for the goodwill of the other players in the game. And that is in essence what the adversarial process is like, is it's orienting people to not just a board game that you could giggle about. They are orienting families to a war that determines what is going to happen to their children, to their property, to their finances, the very essence of everything that they have put their heart and soul into up until that moment. Do not forget or minimize what that experience is like for people. So when we say we're going to do the pleadings first, we want to be mindful of the impact of that. And whenever possible, if they can start working in FDR processes. And for us in particular, if they're going to utilize the collaborative law process, because the collaborative process is saying we are not litigating at all, we can still sign an interspousal contract that identifies the date for property division, any of those legal reasons why people might feel that they need to engage initially in the adversarial method. So this timing, there is the requirement like the stop sign, but then there's also lots of opportunities before you even get to that stop sign. And there are some exemptions where you don't have to participate in FDR. But what I would note for us is that if we think we have a file that qualifies for an exemption, before we bring an application for exemption, we want to consider whether working with a trauma-informed service provider in one of the FDR processes might actually be a better use of resources, because the time and cost in seeking an exemption when you don't even know if you'll get the exemption might be really well spent in a specialized process, one of the FDR processes that has the service provider being very mindful. And of course, where this really comes up a lot is where there's family violence. When somebody's missing, that's kind of different because you can't find them. What are you going to do, right? Kind of hard to participate in something with people missing. So the legislation means what it says in terms of actually requiring this. Under the legislation, though, we might not only see it enforced in this way, a party who fails to participate could be prohibited from taking any further step in the proceeding or filing for further application for relief. Does that really happen? I don't know so much, but this is the teeth behind the FDR requirement. Not only do they mean it, but they really mean it, because they actually go further. This says, hey, if you don't participate, if somebody brings an application, the court could strike out all of your documents, your pleadings, your positions, could refuse to allow you to make additional submissions, could then order you to go to FDR. And I think that's really what ends up happening a lot, or order costs or any other relief that the judge thinks is appropriate in the circumstance. So why does this exist? Well, you all know, because every week we talk about our core values and we talk about why the work that we do is so important for families, but it goes beyond us. And the reason why there's been this legislative change and why these processes are mandatory to participate in is because over time, society has come to understand the impact of interpersonal, the impact of conflict on interpersonal relationships, family systems, and specifically children. So DR processes are designed to try to help people move beyond their positions, to really be able to think about and find ways to articulate their priorities, their expectations, assumptions, concerns, and goals. For those of you who've had mediation training, you know that's the acronym for PEACH, right? Is that those are the kinds of questions we're trying to help people to articulate, because underlying those interests, they have closely held values and beliefs, needs and fears that then, once that's properly understood, the options for how they move forward can be canvassed in a meaningful way that then they can have ownership of for the implementation. And maybe they're going to need some help with the implementation. That is perhaps where a parent coordinator would kick in if there's a parenting issue, where perhaps a financial neutral could kick in if they need some implementation help for refinancing or figuring out a budget, etc.